You are looking at the one form that can override your entire will. A beneficiary designation slip. It doesn't matter what your lawyer wrote, who you promised your 401k to, or how recently you updated your estate plan. This single document can hand your life savings to an ex-spouse, a stranger, or the government. And a blank box on this form has torn more families apart than any courtroom drama. Every year, millions of Americans fill out these forms and never think about them again. They check a box, write a name, and file it away. But that piece of paper doesn't forget. It waits. And when it activates, it can hand everything to an ex-spouse, leave your children with nothing, and break a family apart before the funeral even ends. The law behind this form was built on a principle that shocks most people when they hear it for the first time. The principle that shocks people is simple. Your retirement account, your life insurance, your annuity, they are not part of your will. They are separate contracts governed by a different set of laws entirely. When you sign a beneficiary form, you are not writing a wish. You are signing a binding contract that tells the financial institution exactly where to send the money. And by law, they must follow it, even if your will says something completely different. Even if you divorced that person 20 years ago, even if you told your entire family you changed your mind, that form is a locked box that no probate judge can open. In 1994, a man named David Egelhoff learned this lesson from beyond the grave. He divorced his wife Donna, and 2 months later he was killed in a car accident. He had meant to change his retirement plan paperwork. He never got around to it. The plan still read Donna R. Egelhoff, wife. His children from a previous marriage sued, arguing it was absurd for an ex-spouse to collect. The case went all the way to the United States Supreme Court. The court ruled unanimously. Federal law governing retirement plans, ERISA, requires the plan to pay the named beneficiary. State divorce laws don't matter. The children lost. The ex-wife received every dollar. And that is not a rare fluke. Americans hold more than $9 trillion in retirement accounts and IRAs. For most families, that money represents the single largest asset they will ever leave behind. Nearly every one of those accounts has a beneficiary slip attached, and a massive number of them are years out of date. A recent survey found only 24% of American adults even have a current will. The percentage who have reviewed their beneficiary designations in the last 2 years is far smaller. But the ex-spouse disaster is only half the story. The other half is even more devastating, and it starts with an empty box. If you leave that beneficiary line blank, your estate becomes the beneficiary. The asset falls into probate court, where a judge decides who gets it after months of hearings and thousands of dollars in legal fees. The probate process can consume 3 to 8% of an estate's value before a single heir sees a penny. And if your will is also outdated or missing, the state has a pre-written plan for who gets your money. Parents you haven't spoken to in decades. Siblings you never intended to provide for. A minor child whose inheritance is locked up until a court-appointed guardian takes control. But there's one more layer to this, and it's the reason a single blank box has destroyed more families than any divorce decree. Stay with me. The one more layer is this. Even when you do everything right, even when you name a beneficiary and keep it current, one missing word can still derail your entire estate. That word is per stirpes. It's Latin for by the branch. And if you don't know what it means, your grandchildren could be silently written out of your inheritance. Let me show you how this actually works in a real family. Picture a man named William. He works at a manufacturing plant in Ohio. He has a 401k from 15 years on the job. He's remarried, 2 kids from his first marriage, 1 from his second. He loves them all. He names his current wife as the primary beneficiary. Then he names his 3 children equally as contingent beneficiaries, just in case. He signs the form. He files it away. What William doesn't realize is that he didn't check the box that says, per stirpes. 10 years later, his oldest son dies in an accident. 2 years after that, William passes away. His wife receives the 401k because she's the primary. She dies a few years later. Now the contingent beneficiaries kick in, but only the two surviving children. The dead son's share simply vanishes. His children, William's grandchildren, get nothing. Because the form didn't say per stirpe, the distribution goes per capita, by head, not by branch. The dead son's branch is cut off. The money goes only to the survivors, and a family line that William loved is left with zero. Now, this isn't a rare technicality. This happens constantly. And the worst part is that William probably assumed his grandchildren were protected. He assumed the form worked like common sense. It doesn't. The law is precise, and precision means nothing if you don't know the right words. But the destruction gets worse when you name someone who can't legally receive the money. Minor children, for example. If William had named his 6-year-old grandson directly as a beneficiary, the court would step in. A minor can't inherit property. So the money goes into a court-supervised guardianship. A judge appoints a stranger to manage it, and that guardian charges fees every year until the child turns 18. The family loses control. The child gets whatever is left after the fees eat it away. And the child receives a lump sum at 18, no structure, no protection, a teenager handed a check they're not ready to handle. But here is where the entire system converges into a perfect storm. It's not just the beneficiary form. It's the tax code waiting on the other side. In 2019, Congress passed the Secure Act. It changed the rules for inherited retirement accounts. Under the old law, a non-spouse beneficiary could stretch withdrawals over their entire life expectancy. That was called the Stretch IRA. The Secure Act eliminated it. Now, most non-spouse beneficiaries, your children, your siblings, must withdraw the entire account within 10 years. Every dollar they pull out is taxed as ordinary income. If they wait until year 10 and take one massive distribution, they could be pushed into the highest tax bracket. That means your $400,000 IRA might only land $240,000 in your child's pocket after federal and state taxes. And they have no choice about it. That's the quiet tragedy. You name your child as beneficiary thinking you've protected them, and the government takes a massive cut that could have been avoided with a different naming strategy. A trust as beneficiary. A spousal rollover, but nobody tells you that when you are filling out the form at your kitchen table, or when HR hands you the packet on your first day of work. Multiply this across millions of families. Americans hold over $9 trillion in retirement accounts. Financial planners estimate that a significant percentage of beneficiary designations are either outdated, incorrectly filled, or missing entirely. Each one of those errors is a time bomb. And when it detonates, the explosion doesn't just destroy money, it destroys relationships. Siblings sue each other. Children stop speaking to parents' new spouses. Grandchildren learn at 18 that they were cheated out of a college fund because of a box left unchecked 15 years before they were born. And yet, the fix is almost laughably simple. A single sheet of paper once a year. But before I show you the exact process that stops all of this, I need you to see the one mistake even professional advisors get wrong, because it might already be lurking in your paperwork right now. The mistake is this. If you are married and you name anyone other than your spouse as the primary beneficiary of your 401k, federal law and state community property rules may give your spouse an automatic right to a portion of that account. To validly bypass your spouse, you must get a written, notarized spousal waiver. I've seen a case where a husband named his sister as sole beneficiary, thinking his wife would be covered by the house and other savings. He died, the spouse challenged it, and because no waiver existed, the court handed the entire retirement account to the wife. The sister received nothing. And here is the part even experienced financial advisors sometimes miss. The waiver must be plan-specific. If you have 4 retirement accounts, you need 4 separate consent forms. One blanket waiver does not protect you. Miss one account, and your entire plan shatters. But the trap deepens when you realize that beneficiary designations do not just override wills. They also override trusts. Many people spend thousands of dollars setting up a living trust to avoid probate. Then they fund the trust with their house and brokerage accounts, but they leave their IRA beneficiary form pointing to individuals directly. or worse, to the trust itself without the correct legal language. If an IRA names a trust as beneficiary, that trust must satisfy strict IRS requirements to qualify as a see-through trust. If the trust language is even slightly off, the IRS treats it as having no designated beneficiary at all, which can collapse the payout window from 10 years down to 5 years. Your entire estate plan, the one you paid a lawyer to draft, can be undone by a single beneficiary slip that contradicts the trust. But there is a failure point so mundane and bureaucratic that it destroys families every year. The financial institution loses the form. Your company changes record keepers. The original beneficiary document gets misplaced during a system migration. When you pass away, the plan administrator pulls up your file. No beneficiary is listed. Your carefully chosen heir is invisible. The assets default to your estate and go through probate despite the fact that you did everything correctly. Estate attorneys now routinely tell clients to keep certified copies of every beneficiary form and to request a written beneficiary confirmation from the plan every year. Because the call center agent's reassurance means nothing in court. Only the document on file counts. Now, consider the scale of what is coming. We are standing at the edge of the largest intergenerational wealth transfer in history. Analysts estimate that between $30 trillion and $68 trillion will pass from the baby boomer generation to their heirs over the next 2 decades. A massive portion of that wealth sits in retirement accounts, and the surveys tell us that the vast majority of those accounts carry beneficiary designations that have not been reviewed in over 10 years. Divorces, remarriages, new children, deaths of previous beneficiaries. Life events have stacked up silently. The result is a wave of accidental inheritance, vast sums flowing to ex-spouses, to distant relatives, to probate court, while the intended heirs get nothing but legal fees. The court system is already beginning to buckle under beneficiary lawsuits, and the boomers are just starting to turn 80. So, the question is not whether this problem is real. It is whether your form is correct right now. And the good news is that there is a simple, repeatable process that prevents every single one of these disasters. It does not require a lawyer. It does not require hours of paperwork. It starts with a single annual ritual at your kitchen table and a checklist I am about to hand you. It starts with a single piece of paper and a pen. Once a year, the same week you do your taxes, sit down with a list of every financial account you own. Your current employer's 401k. Old retirement accounts left behind at previous jobs. Every IRA, every Roth, every life insurance policy, every annuity, every account where you checked a beneficiary box and never looked again. Call each institution and request a written beneficiary confirmation. Not a phone call, not a voice on the line telling you it's fine. A document in your hand with your beneficiary's name on it. Keep it in a folder marked Beneficiary Audit and date it. Then go down the list and ask 5 questions. Question 1. Is my primary beneficiary still the person I want receiving this money immediately? If the answer hesitates for even 1 second, change it. Question 2. Have I named a contingent beneficiary on every single account? So if my primary dies before me or at the same time, the money does not fall into probate. Question 3. Did I check the per se stirpes box so my grandchildren are protected, or does per capita silently disinherit them? Question 4. If I am married and naming someone else, do I have a written notarized spousal waiver that is specific to this plan, not a blanket form? Question 5. Does any beneficiary designation contradict my will or my trust in a way that could trigger a lawsuit after I am gone? This annual beneficiary audit takes less than an hour. It costs nothing but a few stamps and a quiet afternoon, and it prevents every single one of the disasters I have described. The ex-spouse collecting your life savings, the grandchild cut off by a missing Latin word, the court-appointed stranger managing your child's inheritance, the IRS seizing 40% of your IRA because the wrong beneficiary triggered the wrong payout rules. But here is the detail. Even the most careful checklist can miss. And this is the piece they never put in the HR brochure. The Secure Act carved out a narrow exception for minor children of the account owner. If you die when your child is 5 years old, the 10-year withdrawal clock does not start until the year they turn 21. That means your child could stretch your retirement account across nearly 3 decades of tax-deferred growth instead of being forced to drain it by age 25. But this exception only works if the minor child is named directly as a beneficiary, not as a contingent behind a spouse, not inside a trust, unless the trust meets exact legal specifications, and it only works for your own child. A grandchild, a niece, a nephew, they get none of that protection. The difference between a minor child and any other beneficiary is the difference between leaving behind a tax-efficient legacy and leaving behind a tax bill that eats nearly half your life's work. You did not plan for a tax trap to erase your retirement. You did not plan for your ex-spouse to inherit your 401k. You did not plan for your grandchildren to lose their inheritance to a procedural technicality. But all of those outcomes are set in motion by a single form that sits in a file right now, waiting for you to do nothing. The antidote is a pen, a checklist, and 1 hour a year. And if you are ready to lock this down, I am going to leave you with something that makes all of this permanent. The thing that makes all of this permanent is a beneficiary audit checklist. I have put it together as a free download. It gives you the exact 5 questions to ask on every account, a tracking sheet to log written confirmations from each institution, and the specific language to look for, so no missing word ever disinherits your grandchildren. The link is in the description. Get it. Print it. Use it this year, because the only thing standing between your family and a probate battle is a single form you already have the power to update. We just covered one piece of paper that can override your will. But there are others. Powers of attorney, payable on death designations, trust funding gaps. Each one can quietly unravel everything you have built. If this content made sense to you and you want to lock down the full picture, there is a special offer for you through the link in the first pinned comment. Hit subscribe. Let me know in the comments. Have you checked your beneficiary forms in the last year? I read every single one. Your family's security is worth a single afternoon. I'll see you in the next one.